yea nor yea. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hibner, and on behalf of Judge Bennett and Judge McBrayer, we're pleased to welcome Ms. Peek and Mr. Vowell to this oral argument, which we are live streaming in order to fulfill our obligation to maintain an open court. We are going to conduct the hearing in the same manner as if we were all in the courtroom together. Each of you has 15 minutes, and Mr. Vowell has reserved some of that for his rebuttal. Unless there are any announcements, I will ask Mr. Hibner to call the case.
Isaac D. Rector versus Robert L. McMillin et al.
Mr. Vowell, you have the floor.
Thank you, Your Honor, and may it please the court, my name is John Vowell, representing the plaintiff Isaac Walker, and I have reserved 3 minutes. So I want to focus on 2 things this morning. One, the question of the common law duty to remove hazardous objects that you've left in the road. And second, the question of when you can raise new legal argument when you ask the court to revise a non-final order. And that second question will also deal with the spoliation of evidence and the absence of evidence jury instruction. So for the first point, the common law duty, the trial court said that the driver here had no common law duty to remove this tire debris from the highway as a matter of law. And so I'd like to make 3 points about that. First, I think the trial court failed to recognize the really long-standing, well-established common law duty to remove a hazard that you've left in a public roadway. We cited a number of cases, a couple of a treatise, and a couple, an Amjur and CJS to that effect. And I wouldn't think that would be too seriously contested. And the second point is I've never seen an interstate exception to this duty to remove objects that you've left in the road. The idea that somehow this principle would not apply to the interstate highway system. So as far as I know, this principle, the interstate is treated just like any other highway. It's the question of, for the jury really, whether the object can be reasonably, safely removed. It's just a question of fact for the jury, whether it's safe to remove it. Now the trial court pointed to 2 unreported federal court cases. One by a district judge, the Cooper tire case. This fellow has a tire failure and he's on the interstate, so he goes out there to try to get the tire off the interstate. And he gets hit by a motorcycle, I believe it was. And he tried to blame in his lawsuit the tire manufacturer. Well, of course, that didn't work. The court specifically said, we do not judge the reasonableness of his action. That issue need not be resolved because going out on the interstate is an intervening cause that, stopped the chain of causation. So the second case is called Hensley versus Rector, and the car on the interstate gets overheated and stalls. So unfortunately, we have a drunk passenger who decides to go get water for the radiator. Now, the problem is the nearby business that he wants to get to is on the far side of the interstate. So he's got to cross both lanes of the interstate to get there. And I don't remember if he made it across the first lane, but anyway, according to the witness, he was running as hard as he could go right into the path of the truck that hit him and unfortunately killed him. So that has nothing to do with the case at bar. So we come to then the question of duty. Now, the Supreme Court, of course, has recognized that courts should use a balancing approach when it comes to deciding, determining whether there is a duty
So are you suggesting then that Tennessee hasn't previously recognized this common law duty? And what you would like us to do in this case is be the first court to recognize a common law duty to remove debris that you've left on the interstate?
Yes, and I have to tell you the truth. That's a good question that you've. I can't remember if there were any Tennessee cases, but I don't think I've seen it. So yes, that's part and parcel of the decision.
Well, you didn't cite any, did you, Mr. Vowell?
I don't think so. That's like, if I had, I think that would be front and center in my mind. So no, I don't think I did.
Well, wouldn't the nature of the duty then depend on the type of roadway we're talking about? I could see perhaps on a state highway, two-lane state highway, that the duty might be different than on a interstate.
Yes, I would completely agree. Every highway is different, and a jury would take that into consideration in deciding, whether there was
But first there has to be the duty has to be defined in some respect, and I guess that's what I am struggling with a bit here. I can see that the duty, if any, if we're going to recognize one, to remove debris on an interstate might be less just because of the nature of interstates.
Certainly it might be, and you could also say that it might be more, because if you get a highway such as, you have in Nashville or, urban areas where there's traffic going both ways, and, you've got people getting on and getting off, the interstate has controlled access. Everybody's going the same direction. You could argue, and I don't have to win this argument maybe today, but you could argue that the interstate is easier to carry out this duty on the interstate, because you only have traffic going in one direction, and it's controlled access, So it would be hard for me to envision a situation where we simply have a hard and fast rule that, no, on the interstate this duty doesn't exist, but on I can't think of a highway, what other highways it does exist. It would be hard for me to imagine a common law that would have somehow a bright line distinction between interstate and non-interstate highway.
If we recognize this duty, then we might have individuals you have to be on the lookout for individuals along the interstate picking up items then.
Well, it doesn't happen very often, unfortunately. Whatever highway you're on, if you have this common law duty that seems to be universally recognized, you have this common law duty, and, if people have, the judge mentioned mattresses, all manner of objects get left on the interstate or on any highway.
Mr. Vowell, I may have misunderstood you, but did you say that the trial judge made an interstate highway exception to the duty?
He did not use that term. That's my term.
Well, why? What did the judge say that would make you think there was an interstate? He's relying upon an interstate exception.
Because in the opinion, the verbally rendered opinion, and in the orders, he says, well, I find that there's no duty to get this tire debris off the interstate. I believe that is pretty close to, it's not a quote, but that's pretty close to what he said. And
but the judge didn't say there would be a duty if it was a county highway, but there's no.
He did not say that.
Okay.
Did not say that.
And that's not for the court, though. The only ruling was as to the interstate.
Yeah.
Yes. The only thing, he just said, and I wish I could quote it a little better, he said something like, I find that there's no duty to remove this tire debris from and to tell you the truth, I don't know if he said highway or interstate. I could maybe look that up during the next segment of the argument. So I'm just not sure about that. But anyway, he very clearly said there was no duty, and I think that he weighed the evidence, and in doing so, and this is what the Supreme Court very carefully reminded us not to do. Courts should take care. You have to balance things, and this is why there was the dissent in the case. The dissenting judge says, well, how can you balance things in determining a duty? So the court said, well, there's a balancing approach, but courts should take care not to invade the province of the jury. So I think that's what has happened here. We've got the judge making a decision that in this circumstance, it was not feasible, not safe to remove for the driver. There's no duty, not only did he weigh the evidence, I think that he weighed it wrong, because he said there was
judge finds there's no duty. You're not weighing the evidence, are you?
Well, he weighed the evidence, I think, Your Honor, because he said there was 5 to 7 minutes from blowout to accident. Now, that is incorrect, of course. So I think he has weighed the evidence. And as I say, I think he weighed it wrong. And this points up the fact that this question of duty, I do think he's invaded the province of the jury. And this question of whether it was reasonably safe in this particular circumstance to go out on the interstate and he didn't have to go that far, just over into the second lane, and there's 300 yards between cars. The very light traffic, according to the very capable witness, Mr. Angel. He's got, there's a jury question of whether that is safe to do. And that is what seems to be the court's decision on duty. There's no duty. So I've got just a moment left. Not really time to do justice to the question of when you can raise new legal argument. But in the case, it's a non-final order, of course. Partial summary.
Well, let me just ask you on that point, because I want to make sure I'm clear on this. When in discovery did you request the tire of the Schrake's tire?
Well, by the time it was like that, they requested it about 23 days later, if I remember the timing.
So your client requested when a request for inspection?
No, it was a request to preserve the evidence. It was a preservation letter that was about 23 days later. The lawsuit was filed pretty quickly, like 23 days. And the duty to preserve evidence.
There was no request then to inspect, just a preservation letter?
Your Honor, I cannot remember that fact.
All right, Mr. Val, your time is up. We'll hear from you again on rebuttal. Ms. Peak?
Thank you, Your Honor.
Please unmute, Ms. Peak. There you go.
Good morning, Your Honors. Thank you very much. We have jumped into the heart of the argument with regards to duty, and so if it's okay with the court, I'll just pick up there. Your Honors, duty is a question of law. It is not a question of fact to be determined by the jury. The judges have to make a determination, as we learned in Torts 101, of weighing the foreseeability of harm, the gravity of harm versus the burden of the defendant. And that is a legal question. It does not require or ask the court to weigh evidence, but the court is required to consider the factual circumstances that the particular case arises in to determine under the facts of those cases common law duty exists. In this particular case, it needs to be pointed out that the plaintiff in their second had 4 complaints that were filed in this case. The case had been pending for 7 years at the time the summary judgment was finally heard and argued. And there was a supplementation to the record because the defendant filed a motion for summary judgment in 2016, immediately after the plaintiff's disclosed expert was deposed, to raise this causation issue. The spoliation lucky enough to be the one to litigate it on behalf of the defendant throughout the tenure of the case. The interesting point there is in the plaintiff's second amended complaint, which is contained in the technical record at page 77, the plaintiffs pled on page 80, paragraph 16, subpart D, that defendant had a legal duty to remove, repair, or clean up the dangerous road condition, and then had subpart E, which set forth the statutory duty to remove the tire from the roadway. The plaintiff subsequently amended their complaint to remove the common law allegation, and that was by order that was entered and is contained in the technical record at page 93, where the plaintiff struck that common law allegation. So part of the argument to the court was that the plaintiff did not properly plead a common law claim. The court struggled with whether by pleading a statutory claim that was sufficient to put the defendants on notice of that claim. I just wanted to bring that to the court's attention before we reach the substantive issue of whether or not there should be imposed for the first time by this court a common law duty to retrieve a tire tread within 5 to 7 minutes of a tire failure as a matter of law. The plaintiffs also spent a lot of time arguing that the 5 to 7 minutes is not accurate. That's a question of fact. But it has to be noted that the plaintiffs responded to statements of undisputed fact, as is procedurally required under Rule 56. Page 497 of the technical record contains the plaintiff's response to statement of undisputed fact number 14, which stated, approximately 5 to 7 minutes passed between the time the defendant's tire blowout and the plaintiff's accident. And the response by the plaintiff, which I would submit that they are required to stick with, they can't change it now, is plaintiff admits the averments contained in paragraph 14 for the purposes of summary judgment, of the summary judgment matter. That is an undisputed fact for purposes of analysis for this case. So I think those are important for the court to recognize, in addition to the fact that the plaintiff did plead in their fourth amended complaint that the tire was on the roadway for 7 to 8 minutes. So the statement of undisputed fact that the plaintiff affirmatively agreed with is binding for purposes of considering the summary judgment and evaluating the common law duty question. So
let me make certain that I understand you. Your position is the plaintiff did assert a claim under the common law duty to remove debris, but then withdrew it in a subsequent complaint. Is that correct?
yes, Your Honor, and that is supported by order.
And it was not reasserted.
Correct. The only thing that remained in the fourth amended complaint was the statutory claim which rested on 55A136, which the court disposed of on motion for summary judgment, as that's a motor vehicle operation statute and does not involve duties that occur after an accident or an incident occurs, and I don't believe that issue has been raised on this particular appeal.
All right, I was going to ask you about that. I'm not aware of there being a statutory duty to remove debris, and you're saying there's a statute, but it doesn't apply to the facts of this case.
Correct. The plaintiffs relied on and pled in their fourth amended complaint 55A136, which is an exercising due care in the operation of a motor vehicle statute, which the court granted summary judgment on that aspect. I will, for candor, the plaintiff attempted to argue when they were arguing their spoliation argument after the summary judgment was granted, identifying some metro ordinances and some other efforts to resurrect their statutory claim, but the court determined that those were not pled. Those were not the traveling statutes that the plaintiff was relying on in any of their amended complaints. And so when ruling on the Harris versus Churn motion, was disinclined to allow amendment at that point. If I can go back briefly just to the common law duty issue, which, as I mentioned, is a judicial duty to, not to double play the word duty, but the court has to determine if there's a duty by weighing the factors of the possibility of harm to a plaintiff versus the burden on a defendant to, in this case, the operator of the vehicle, to run out into a roadway. And I do think it's dependent on the type of facts that we have case, the defendant was traveling on I-24, which is an 8-lane interstate highway with a speed of 70 miles per hour. And there was a tire failure that occurred, and that tire was left in the roadway. The court analyzed very carefully. Judge Binkley had a 5.5-hour hearing on our motion for summary judgment and thoroughly reviewed the cases and issued its ruling. And the court took into account, and we have pled and briefed 2 Tennessee cases that Alita Trogger ruled on in Vice versus Cooper Tire, and then the Hensley versus Rector case, both of which found that a pedestrian who ran or walked in an active travel lane of an interstate were grossly negligent for doing so. And in fact, they both rely on statutes that prohibit pedestrians from traveling on a walking or being present on a travel lane of an interstate highway. The court found those cases persuasive, and I would reiterate that the cases identified by the plaintiff are cases not from Tennessee. There is not a Tennessee case that anybody has produced, and I've looked pretty diligently identifying any type of common law duty in this circumstance to retrieve debris. The plaintiff cites cases stemming back to 1931 in a multitude of those cases, save one will have jurisdiction that impose a duty to remove debris from the roadway. Can you all hear me?
I was gonna say, Ms. Peak, you might pause for a minute. You were breaking up for about the last 15 seconds there. So you had said that there were no Tennessee cases that create a duty to remove a hazard that's caused by your vehicle, and you can proceed from there.
Yes, thank you. The plaintiff does cite about 6 cases from other during 31. Each of those cases, except one, rely on statutory codes within those jurisdictions for determinations of whether a duty existed. The other case is a Louisiana case from 1968. It's called O'Reilly versus State Farm, and that case relied on res ipsa as a theory. The plaintiff in this particular case withdrew the allegation at the motion for summary judgment hearing. That was an aspect of the motion for summary judgment. The plaintiff conceded that they were not a res ipsa argument. So we would submit that the cases that the plaintiff relied upon to assert a common law duty, that the 2 federal cases decided in 2016 and 2005 respectively are highly persuasive to suggest that we should not be asking citizens of the state of Tennessee to be running, walking, entering a travel lane of highway for purposes of removing debris and imposing that duty on drivers from, age 16 to age 89, and ask drivers then to be looking for pedestrians on an interstate highway. And
Tennessee
I'm sorry.
Does Tennessee have a statute that says don't walk on the interstate?
Yes, Your Honor. It does, in fact. I would have to find it. It was cited in the Vice case. There is a statute that it's 55-8-138, which governs a duty for pedestrians on a roadway. And the federal court relied on that statute in Hensley to suggest that the pedestrian who was struck was grossly negligent for entering the highway. So we do believe that there are statutes that would prohibit the conduct that the plaintiffs are requesting in this case. And that's one of the factors to be considering when we're weighing the foreseeability of harm versus the gravity versus the burden to the defendant. We also asserted in this case, and for those reasons, we would submit that there should not be imposed a common law duty for operators of vehicles or pedestrians to enter traffic lanes of highway. This is something that TDOT undisputed statement of fact, the plaintiff came upon the tire and swerved uncontrollably to avoid it, which is how this accident occurred. If there aren't any questions, I would like to move briefly to the spoliation issue and the sanction. The plaintiffs argue in their briefs that Harris versus Turn and 59.04 were not the right standard. I would point out that it's the plaintiffs' moving papers that set forth the standard under Harris versus Turn. It is the appropriate standard, both to consider new evidence as well as new theories or legal arguments. That's clearly set forth in Harris versus Turn. And there are a number of factors that the court should consider, and that is an abuse of discretion review for the Court of Appeals. Judge Binkley very carefully analyzed, painstakingly so, the duties, the factors set forth in Harris versus Turn when it's appropriate for the court to consider newly raised arguments and newly raised evidence. We would submit that the court did not abuse its discretion. In the court's order, the court relied on factors 1 and 3 primarily, which would be the plaintiff's knowledge and familiarity with the argument. Was it truly new evidence? And also the plaintiff's arguments or evidence for why they didn't raise it initially. The spoliation issue, Judge McBrayer, to your point, there was never one discovery request to the defendants to produce the tire. There was not one deposition to a corporate rep asking what happened to the tire. There was no discovery whatsoever to produce the tire. There was no deposition of Best One. There was no subpoena to Best One. These are all resources within the plaintiff's arsenal to identify and discover that evidence. As Mr. Val pointed out, plaintiff's counsel was retained very, very early on in the case, and they certainly had the means to investigate the whereabouts of that tire.
So why doesn't that just resolve that issue? I mean, I can appreciate that there was a letter sent out, a litigation hold letter sent out, but if you never request it, why isn't that doesn't that just do away with that issue?
Yes, Your Honor, I would submit it does, and I think that weighed heavily on the court's decision under the Harris versus Turn factor that the plaintiff knew about it, didn't do anything about it, waited until after the summary judgment was in essence granted to raise this, really without any supporting evidence that the defendant did anything or didn't do something to preserve that evidence. So I would agree with you, Your Honor.
Yeah, let me go back to the duty issue again. Judge Bennett asked the question I was thinking about the prohibition about pedestrians on the interstate. Is there any exceptions to that? You know, if your car breaks down, can you not walk to the nearest exit to get away from the interstate? I mean, or is that just an outright prohibition with no exceptions?
Your Honor, I believe the duty analysis has to be undertaken in light of the facts of a particular case. I've handled cases in my career involving vehicles that have stalled on the highway at night, the lights are disabled, and there's different circumstances, I think, that have to be considered. The court was asking what Judge Binkley ruled, and the order is found on page 865, and the court's ruling was relying on Bryce and Hensley. The court finds that it is not a normal response for a person to enter a 6-lane interstate with vehicle speeds of 55 to 65 miles per hour on foot without any safety protocol in place to retrieve a piece of tire that came off his vehicle. Therefore, the court finds that there's no duty for defendant McMillin to retrieve the tire
I want to go back to the question of was there a discovery request. The plaintiff's expert went, and they learned, they went to look, and the tire wasn't available, and they learned that it wasn't available, and
that's when the plaintiff steps in and then does a discovery request and says, produce this for inspection.
well, he would be asking for the production of something that didn't exist. So if they learned that it didn't exist, there's no point in doing a request. If it doesn't exist, it's gone.
No, I mean, the point is that sets up your spoliation
Yes.
argument.
Yes, it doesn't. And the duty to preserve evidence, it doesn't depend on a preservation letter. It arises immediately. I learned that the hard way in Gardner versus R&J Express. Your duty to preserve evidence arises as soon as you realize it might be a lawsuit. And that was immediately in this case. So I want to mention a couple of other points. The Interstate seems to be growing. Council said it was 8 lane. I think it was 6. But the point is that the tire was the carcass was out there. We don't want the Tennessee citizens to be required to run on the interstate. Well, there's no running involved. They're just take a few steps over there.
Well, you never run. I mean, even at 70 miles an hour, the closure rate over yards is 34 yards a second.
Well, you've got 300 yards.
Less than 10 seconds.
Well, you can step over there. I think it's a jury question of whether someone, you've blown your tire out, you're running retreads on all of your trucks. The jury can determine or can decide that they're running retreads. They shouldn't be having all those blowouts. My goodness.
Well, but that's, to me, that's sort of the missing piece here. But that wasn't what this suit was about. It was about, it's now boiled down to whether or not there was a duty to remove the retread or tire carcass from the interstate, rather than were they negligent in the way they were operating their tractor trailers and using deficient tires on them. But that's not this suit. That's another suit.
Well, this suit is whether it was negligent or not. The cases are very clear that if you're responsible for something being out there on the highway, that you have to get it off. That's your duty if you can do so reasonably safely. And that is, the law everywhere.
All right, thank you, Mr. Vowell and Ms. Peak, for your arguments today. We will take this matter under advisement